Swayam Prabha. Digital India. Educated India.
Greetings of the day. Now I start with the next lecture, the fifth one. Nullification or impairment of benefits accruing directly or indirectly to other members under GATT 1994. Now, firstly, what do we mean by the term nullification? Nullification means whatever benefit that was being obtained or the benefit that any such industry of a particular country was getting is no more able to get that kind of benefit, or sometimes that is totally zero, or that has now turned into losses. That is what we mean by the term nullification. Impairment is the it can be explained as in the form of price suppression or price depression. Impairment, price suppression, price depression. This means the extent of profit it was getting, the industry of that particular country is not able to attain, and sometimes it has to lower the price of that product. This lowering of price of the product is out of compulsion because it is now facing competition with the like product being manufactured by that particular country. I explain this in a more illustrative manner. Now, take the instance country A, country B. Country B was exporting its product to country A. Now, country A started manufacturing the same like product. Like, let's say X is a product, X is product. This was exported from B to A. A started manufacturing this product X. Now, this manufacturing the product is not a problem, neither giving initial support or initial state support in the form of subsidies a problem. But let's say the state support continues beyond infrastructure support. Beyond infrastructure support, or it continues beyond 5 years. Now, what will be the effect? The effect will be the X product that is being exported from A, either there will be no such export because it is facing losses, B is facing losses. So, A, in order to get its product being sold in a very large scale in its home market, starts giving subsidy. Therefore, B has to withdraw its product. Or it could be that B has to reduce the price of the product in order to sustain in A's market. That is what we mean by impairment of benefits in the form of the price depression. Sometimes there is a price suppression. What is price suppression? That let's say after every 5 years there has to be increase in the price of that product, maybe by double the amount, maybe half of the amount. So, if the original price is $10, so after 5 years it has to be $15. That is how the natural way we define the things, or depending upon the natural market forces. But now, since it is facing competition with the like product from the country A, which is actually not a natural competition, but the competition created because of the subsidies or state support being provided by the country A. Therefore, it has to suppress its increase in the price. So that is what we mean by the term here, nullification or impairment of benefit accruing directly or indirectly to other members under GATT 1994. Now this can be not only confined to the trade relationship existing between two countries, it can be that there are several countries involved in manufacturing the product, and not only manufacturing the product but exporting it to country A. So let's say the same can be, I have explained right now to you, quoting the example of two countries trade relation. Now let's say country A, where the goods are exported, or I put it here, imports the goods. Now who all are exporting to country A? That is, let's say country X, country Y, country Z. It could be that all of them are getting affected because of the subsidy policy of country A. Now what we need to be very clear, whether we say this as prohibited subsidy or an actionable subsidy. So this was basically an explanation on actionable subsidy, because initially it was justified. Initially the state support was justified, but it became unjustified after it has reached to this stage, nullification or impairment of benefit accruing directly or indirectly to other members under the GATT. Why it is so? Because so long as the exports from X, Y, Z, they were not affected, and product from country A was also sustaining in the market, there is no problem. We can continue with that form of subsidy. But the moment the support from country A to its product increases or remains there, which affects the product from country X, Y, and Z, like product, it should be the matter of like product. That means if we are talking here about television set, that means television set from all the countries. If we are talking about cars, then cars from all these countries, not that we start comparing cars and television. So in that case, we consider this as a nullification or impairment of benefit accruing directly or indirectly to other members under GATT 1994. Serious prejudice to the interest of another member. Now similarly, it says sometimes it is a matter of serious prejudice that something has not happened, but there are chances the effect could happen, so that creates prejudice, serious prejudice to the interest of another member. So that is also covered under that kind of state support, which creates skepticism in the product, skepticism in the manufacturer of another country, that can be covered under this serious prejudice to the interest of another member. Actionable subsidy and specificity. So we need to correlate it, the actionable subsidy, how specific it is with regard to a particular industry. Simply saying the subsidy is being given by a particular state, let's say country A belongs to Africa or country A belongs to Asia, which is transforming its economic system from rural setup to industrial setup. Now that is very natural. The same country will give state support, or it will provide subsidy or give infrastructure support to its industry. That is not we consider as actionable or either the prohibited category. Now in order to cover it procedurally under the actionable terms or actionable subsidy, we need to clarify whether it is for a specific group of industries that are in competition with export of products, or they are facing competition with export and import of like product or not. So subsidies and countervailing measure agreement provides that a subsidy shall be actionable only if such a subsidy is specific and causes adverse effect to the like product of another country. What are those adverse effects? As explained right now: serious prejudice, injury to domestic industry, nullification and impairment. Next category is, now prior to this I would also like to explain one more thing. Now what can be the criteria to state that this kind of state support seems to be active? There can be certain criteria also. It is not simply that every case has to be tested. Sometimes we can simply, merely by noticing it, or merely by knowing what kind of policies are adopted by the government, we can initially say, or there has to be a clear guideline to the state that you should not cross the limits. There has to be a guideline, and WTO under subsidies and countervailing measurement agreement has created those guidelines. So there are two checks here that subsidies can be considered as actionable. One is the time period. That means if a state is providing state support to a nascent industry for 5 years, well, that is fine. But if it continues for 10 years, 15 years, or maybe it is not stopped, so then definitely that will fall under actionable category, and sometime even prohibited category. So to what is the time duration up till which that state is providing its support, that is one such issue here, in order to make it whether it is actionable. Next is the extent and volume, extent or volume of support. Now, what is the extent of support? If the government says that, okay, we are initiating an iron industry, we are initiating car manufacturing industry, where 80% of the cost will be taken by, or that will be borne by the government, that is definitely a blatant abuse of the rules. So maybe up till 10% of the total cost, 20% of the total cost, there has to be a certain limit, or 25% of the total cost, whatever is the net expenditure. So some percentage, some minor percentage of that can be shared by the government or can be supported by the government. And then to what extent, that is the time period. These two are very crucial factors to know whether the state has framed a policy that does not fall in the actionable category, but that falls under the justifiable category. Next category is non-actionable subsidies. As I have explained to you earlier, that in the WTO rules we have mainly three types of subsidies. One is prohibited, the second one is actionable, and the third one is non-actionable. Now the third one, that is non-actionable, is obsolete. It's no more functional. That means no one can make a claim that this kind of state support falls under non-actionable category nowadays. They only can draw the distinction that we have the state support for these and these purposes, and it is not affecting the trade interest of a particular group of country, or it is not affecting the exports from the particular country. So we can, and that is in the larger interest of the society, so we continue with these kind of state support. So that is what we mean by the term non-actionable. Basically, they are not meant for profit purposes, they are not meant for business interest, rather they are in the larger interest of human beings, larger interest of the society, where the state does have its responsibility. So that is what we mean by the term non-actionable subsidies. Now, what are those? Assistance for research activities conducted by firms or by higher education. As we all know, that research activities are quite risk taking. The industrial setup or the industries, they cannot bear that much expenditure, or they cannot invest that much of funding in research activities. Of course they do invest, but not in all kind of research activities they can involve themselves. So therefore they seek the assistance from the state. And since research is something that has an added value to the society, to the humankind, or to the people at large, like the pharmaceutical companies, they are producing, or they are innovating new kind of drugs, so that simply they cannot do this on their own, or they have to rely upon, or they need certain form of support from the government. So that is covered under the non-actionable form, that is assistance for research activities conducted by firms or by institutes of higher education. Basically, these research work is done in collaboration with higher education. We have these incubation centers. So all that kind of support for those centers or for those institutions is exempted. Or the assistance cover not more than 75% of the cost of industrial research or 50% of the costs of pre-competitive development activity. Now even that kind of state support is not arbitrary, or there is a cap to it also. The assistance cover not more than 75% of the cost of industrial research. That means whatever is the amount supposed to be spent, or the total cost, 75% up till that is the outer limit where the government can give the support, or government can give the state support in terms of financial contribution. Assistance covers not more than 75%. Beyond 75%, it is not permissible. So that will be then covered under the actionable form of subsidies of industrial research, or 50% of the costs of pre-competitive development activity. Now, sometimes there is a infrastructure support that is definitely covered up till 75%. Sometimes we allow the product to be produced or product to be manufactured, but that is then at its trial stages. We do not know what will be the outcome, whether the market will be accepting it or not, what will be the reaction of the market to it. So if we have to go with these risks, then there is a requirement of the government support, but that support can be only to the extent of pre-competitive development stage. Now, what is pre-competitive development stage? That means when there are like products available from different countries and they are already established in the market, but they will not be affected by this new product of like nature that is launched. All right. For example, let's say if there is a new toothpaste being launched. Toothpaste is simply an example. We do not say this as a drug or as something which is of great innovative value, but just an example. Then the new toothpaste, maybe that is very effective or that has its own medicinal properties, but then it will not be so easy for that toothpaste company to, let's say, beat the or give the challenge to the already established Colgate, Palmolive, or various other brands that are very popular or they have their established market. So up till that extent, any such support being given by the government is acceptable. But let's say the government allows the new toothpaste or the manufacturer of this new toothpaste to reduce the price of that product to the half of its original price. Let's say that is for 50 rupees or 100 rupees, but because of the government support, its price is reduced to 50 rupees. Now, if that is half of the price of the toothpaste that are available in the market, so definitely it will have its competitive value, or even if it has lesser qualitative value, it will be able to emerge in the market and may try to break the established monopoly, or let's say if not monopoly, the established market pattern for those branded products or branded toothpaste that will be affected. So in that case, we cannot accept that kind of state support as a non-actionable subsidy. That will be fall in the category again of the actionable part, and that here it is barred, that the government or the state cannot extend its support in the form of financial contribution, or whether it's in direct sense or in the indirect sense, where it is ready to bear 50% of the cost, but that 50% of the cost is acceptable only up till the pre-competitive stage. The only thing is we need to be very clear what is this pre-competitive stage. That is a very relative term because we need to make it clear. Now, in order to make it more objective, the pre-competitive stage, we get back to what was explained in the actionable subsidy, that it is impairment of benefit, nullification of the interest, nullification and impairment of benefit, adverse effect, serious prejudice. So if it creates all these kind of market pattern, then definitely we cannot put it in the non-actionable category. So long as they do not generate these kind of market forces, then we can consider it as a non-actionable subsidy. But that is only in here we need to draw the distinction mainly if it is for a new product or for product that has an innovative value, not something a new company can ask for a non-actionable subsidies, but it has to show what is its innovative value. Assistance to disadvantaged regions within the territory of a member given pursuant to a general framework of regional development. Now, further, it also allows non-actionable subsidies allows if state support is being given to disadvantaged region. What are disadvantaged region? That is like desert area, very tough terrain where the human survival is very difficult, very cold places. So all that kind of support being given, they are exempted in both from prohibited and actionable subsidies and are covered as non-actionable. Why? Because that kind of support is necessary even for the human survival. So assistance to disadvantaged regions within the territory of a member given pursuant to general framework of regional development. That is mainly with regard to giving support for development of that area. The state is providing support. For example, let's say if Indian government gives state aid, or let's say it gives financial support to the in the form of reduction in price of the products that are sent to Ladakh region or in remote areas, so that will not be covered as actionable subsidies. Now, next is Article 27, special and differential treatment. Now, prior to this, I would also like to explain one more category of subsidy that has not been exhaustively covered under the subsidies and countervailing measure agreement. That is artificial devaluation of currency. We have discussed here three categories mainly, that is prohibited, actionable, non-actionable. Mainly these are with regard to production of goods and the sale of goods, whether it is at a pre-competitive level or at a competitive level. But what about the financial aspect? Now, basically, WTO is linked with International Monetary Fund, so maybe they have not taken into consideration the financial aspect. But we cannot ignore, since we try to define the prohibited subsidies in that category, which is meant for increase in the export. Now, what is artificial devaluation of currency and how it affects the export, or how it can be considered as kind of export subsidy? Artificial devaluation of currency. We all know that dollar is the standard form of currency, that is US dollar. Okay, all the currencies of the world are compared with the US dollar, and they have the right to give the value to their own currency, and that will based on various factors. They cannot do this arbitrarily. There are certain considerations they must, and certain conditions they must comply with, and based on that, all the nations of the world, they value their currency. Now the question arises, if a particular country, let's say the $1 of one value, I take the example of China, which is pointed out for this artificial devaluation of currency. It's not that I'm trying to prejudice or create any effect in the mind of the audiences, but this was an article widely discussed, that whether it's the artificial devaluation of Chinese yuan that has led to increase in its export. Now, let's say the value of $1 is equivalent to 10 Chinese yuan. All right. If this Chinese yuan, this is further depreciated. Okay, now it is for $1, it is 12 yuan. That means its value has gone down. Now, what will be the effect? What will be the effect of devaluation? The export from China will increase. How the export from China will increase? Because the Chinese export will become cheaper in comparison to its valuation based on the US dollar. So earlier, someone had to pay $1 to buy a product that was of this value, but now the same person, I mean, since the product has become cheaper, that means the Chinese currency has gone down. So maybe it has to pay 0.8 US dollar to buy this Chinese product. Now, what will be the effect? There will be increase in export from China. All right, because Chinese product becomes cheaper. Why they become cheaper? Because Chinese currency value has depreciated. So that will automatically lead to the high export of Chinese product throughout. And as a consequence of it, that country, like for example US, it will have to import, or it will start importing much of the Chinese products, and at a later stage it may fall into a trap, that is adverse balance of payment. That means its import bill will be higher, because the Chinese people, because of the reduced value of their currency, they will not be very much happy to buy imported products. So the export will get the boost and import will be reduced. That is the effect of the artificial devaluation of currency, and that has actually happened. If you try to figure out what is the trade relationship existing between China and US, you will come to know that the US is facing unfavorable balance of payment, or it is facing balance of payment crisis in this term, and China is facing a positive or a favorable balance of payment. Now, it is not only confined to this effect, that the export has gone higher of a particular country where it has devaluated its currency artificially. There is a distinction between artificial devaluation of the currency and real devaluation. Real devaluation means the prime factors that has stabilized the currency, or the factors that had given the value, they themselves call for reduce in the value. Okay, that is like a genuine thing. That can be many factors, like the growth has gone down, or the government is not able to pay its import bills. There are various listed factors. But artificial is something that is not dictated by those factors, but it is induced by the government to increase the export. So that is where the real danger lies. Now, this is the first step, the increase in export. After increase in the export, the second will be, there will be increase in the export earnings. That means more dollar or more of the foreign currency will be available in the Chinese account, or in that particular account of that particular country. This has happened long time back in US, where US was facing a very severe depreciation when the value of dollar was purely based on the gold standard. Nowadays it is not purely based on the gold standard, but it is partly based on the gold standard and also on the flexible exchange rate. Now, when the US dollar was based on the gold standard, it it faced an adverse balance of payment with other countries. That means there was more of the dollar outside US than in the US. And since the value of the currency was based on, US dollar was based on purely on the gold standard, there was a fear that if all those countries, or the citizens of all those countries, they ask that in return of this dollar pay us in gold to the American bank, then the country will start losing its gold deposits very severely, and the country will be in a deep crisis. So that should not happen. So therefore they jumped into partly gold standard and partly in a flexible exchange rate. Now, similarly here, if any particular country has increased its export by devaluation of currency, the problem does not remains up till this point. It can be a very large scale problem, that the same country can later on dictate its term in the international financial market. Like it can ask payment to be made in that particular country or currency, or if the payment export bills are paid in that particular currency, that then it will be cheaper, and otherwise they will have to pay more amount. So that is the problem here. Now, coming to the next part of it, the subsidies agreement. Special and differential treatment of developing country members. Now, as I stated to you, that in the preamble it is clearly mentioned that the WTO has prime consideration to raise the standard of living, to create opportunities for developing and least developed countries. Now, that opportunity cannot be created if we take into consideration the prohibited category of subsidies strictly. That means we do not allow the state support being provided for increase in for startup of industries, mainly in the developed and less developed countries, or we do not allow certain concessions and flexibilities when it comes to developing and less developed countries. That means there will be a clear contradiction between the objectives that are mentioned in the preamble and then what is listed or what is further explained in the specific agreements, as subsidies and countervailing measure is a specific agreement. Now, for this reason, under Article 27 of the Subsidies and Countervailing Measure Agreement, this article has been included, which is meant for giving special and differential treatment of developing country members. Now, this is with regard to the generalized system of preferences. There are preferences given to the developing countries, mainly the goods from the developing countries, through generalized system of preference. That preference goes to the developing countries that are listed, and the products that enter into the European market or developed country market, then they may have to pay less of the duty, or they may, even if they have produced those products by giving subsidies, that will be permitted in the market of European Union or market of United States, because they are exempted under generalized system of preferences. Now, then there is another category, that is special and differential treatment of developing country. Keep in mind, we have classified yesterday what do we mean by the term developed, developing and less developed countries. Now, there cannot be one single parameter to say that this particular country is a developing country. There are various factors that determine it as a developing country. And all the developing countries have different situation, they have different market considerations. And it could be the policies adopted by the developed nation to get the goods from a particular developing country may be beneficial, but they may not be beneficial to others. For example, let's see, China also consider itself as a developing country. India also consider itself as a developing country, and there can be other examples like Malaysia as a developing country. Now, if all these three countries, they are sending their product to US or to European Union, then if and all the goods from all these countries are given equal preferences, even that will not serve the purpose, because we have to consider that the prime objective is creating more opportunity, creating more employment opportunities, raising the higher standard of living. So, if a particular group of country or a particular country within the developing country group or within the less developed country group requires more support, for example, if we add here the three examples I have quoted here, China, India, Malaysia, let's also add Africa. So, if Africa is also treated, or some countries from Africa are also treated as developing country and same preference is given, that will not help the African economy. So, there has to be a special consideration being given that within the developing country group, the nations from Africa require more support. So, firstly, we will reduce the tariff for the goods that are being imported from Africa. The tariff rate will be 10%. The goods that are imported from India, China and Malaysia, the tariff rate can be 15%. Let's put it like this: if US make a policy of such nature, or European Union makes a policy of such nature, so that means it is creating special and differential treatment of the developing country members, and the general tariff, it says, is for 20%, like I put it here. US import policy, same goods from developed country, %20 tariff, goods, same good from developing country, 15% tariff. Same goods from African country, 10% tariff. Now you see, that is what it means, because they know the economic support for Africa is more essential. So in this way they can create the differences. Now here they can, in this developing country category, they can further categorize. This cannot be simply as strict as 15%. It can be, in if it is Sri Lanka, then it can be even 12%. In India it can be 15%. So if a developing country is facing crisis or in a lower strata, then further differentiation can be made. Members recognize that subsidy may play an important role in the economic development programs of developing country members. The prohibition of paragraph 1A of Article 3 shall not apply. Now, as stated to you clearly, that all those prohibitions that are mentioned in the prohibited category of subsidies are not applicable in case of the developing country members and less developed, that falls under Article 27 of the Subsidies and Countervailing Measure Agreement. Next is also the same exemptions are also for developing country members referred to in Annexure 7. Other developing country member for a period of 8 years from the date of entry into force of the WTO agreement, subject to compliance with the provisions in paragraph. Now, the countries that are referred in Annexure 7 or the other countries, who all are they? They are those group of countries who were formerly part of Russia, the Soviet Union, the so-called Soviet Union. When they disintegrated, when Russia got disintegrated and these new countries emerged, so they had a closed economy, a very strict closed economy regime. And it takes time for them to adopt the new model of economic setup, mainly for adopting the free trade objectives. So they are given more relaxations and more time period for further reformation or further transformation. Other developing country member for a period of 8 years from the date of entry into force of the WTO agreement, subject to the compliance with the provisions in paragraph. So these developing countries are given the time period which exceeds, or sometime even exceeds 8 years, but the general time period is 8 years from the date they have joined the WTO membership. Article 29, transformation into a market economy. Now, what is that market economy setup? The economies that were earlier the closed economies or the part of former Soviet Union, they are now part of open market economy. So they have been given different time period, or let's say different considerations for their transformation, and that is covered under Article 29. Members in the process of transformation from a centrally planned into a market economy, the free enterprise economy, may apply programs and measures necessary for such a transformation. Now, there are some of the important cases where I have listed two such important cases: Airbus Boeing dispute and India's quantitative restrictions on import of agriculture, textile, and industrial products. The Airbus dispute is one of the very landmark cases that came before the WTO. That is not only confined to subsidies in terms of financial gains, as we have discussed that there is a financial support, and that financial support leads to benefit, and that should be to a specific group of industries. But here it has gone even beyond that. So firstly, I start the history, how it started. The European Union is manufacturer of the famous Airbus, or it manufactures the commercial aircraft that is known as Airbus. United States manufactures the commercial aircraft that is known as Boeing, or popularly it has the aircraft manufacturing company known as Boeing. And they both, European Union and United States, they have been in the practice of giving subsidies to these aircraft manufacturing companies even prior to inception of the GATT. A long time back they have been giving. Now, but why they have been giving such support. Since the aircraft manufacturing is an expensive process, it has not only an expensive process, but also a lot of risks are involved. And a private entrepreneur or a group of entrepreneur, they cannot take that much of risk. There are risks in several stages, right from manufacturing up till the selling point. So the state intervention is required here. Yesterday I was explaining to you the concept of plurilateral agreement. So certain countries, those who are manufacturing this civil aircraft, they have signed a plurilateral agreement. Based on that plurilateral agreement, they have accepted giving state support to a certain extent, that is of different nature in comparison to what subsidies we have discussed right now. So the Airbus company was giving subsidies to, or the state support to its, sorry, European Union was giving state support to Airbus company. Now what is Airbus company? It is basically supported by, or the company is supported by Britain, Germany, France, Spain. It's not owned by a particular country, but it is a state support company where Britain has partnership, France has its own share, Spain is also giving support, and Germany also provides a very strong technological support. So these are a group of countries, they are supporting Airbus company. Whereas Boeing is basically an American company, and it is supported by the state government or the provincial government of various states from the United States. Now they had the rivalry. So how the rivalry started? Basically it was the Airbus company which launched long time back, that launched the commercial aircraft to the world, and they became popular. The Airbus company started becoming popular. At that time Boeing company was also manufacturing aircraft, but they had not been able to launch their aircraft to the world at large. They are more the domestic players. So later on they, like the Boeing, Lockheed, and another companies, they combined together, and then they started making this big aircrafts, and then they started selling it to the world. So they sold different models of the aircraft, and they had a strong rivalry. Like the one model of aircraft produced by Airbus was in direct competition with that of the aircraft produced by the Boeing company, and that led to giving more and more state support by both the sides. European Union was giving too much of state support to the Airbus, and Boeing was being supported by the United States. Now it was not only they wanted the more aircraft to be sold by these companies, but it also affected the economy. Like the more of the aircraft being sold by the Boeing company, there is a more economic boost to the US system, or the US economy gains a lot by selling those aircraft by the Boeing company. Likewise, more of the Airbus being sold by the European Union or by this Airbus company, it gives an economic support to the European Union. So that was the reason the state's involvement was there. And because of this rivalry between the two economic blocks, that led to a direct competition between the various models. Like if Airbus was producing one model of the aircraft, after a certain period of time, a parallel model was produced by the Boeing company, and at a cheaper price, or let's say an advanced model was produced. So this led to a kind of competition, between a very unhealthy competition between these two companies. Now finally they realized that this is not fair, so they entered into an agreement that they will not, neither European Union will give much of the state support to its Airbus company, neither Boeing company will get more of the state support from the United States and the provincial governments. But that could not succeed. So later on, when WTO was formed, they gave this in writing before the WTO, that they will try to restrain their state supports, and also they will try to resolve the disputes between themselves, not entering into the dispute settlement understanding, or not allowing the dispute settlement understanding to get involved in their confrontation. So they agreed upon it and they worked. This continued for several years, but finally, what happened? The This agreement failed, and both Boeing company and Airbus, as a consequence of it, they started giving unrestricted subsidies, or not only subsidies in terms of financial support, but Airbus was getting support also from European Space Agency, and Boeing company was getting technological support from NASA, that is their space agency, because they all wanted to show that they both can produce an exceptionally good aircrafts. So now this led to the dispute being brought before the WTO, as both the parties, they were not restraining and they had crossed all the limits. And this time the state support was not simply in the form of financial contribution or in the form of infrastructure support, but also the advanced technological support being given by their space agencies. So that finally led to the call before the WTO. So the WTO very well in this case decided that the technological support being provided by the NASA to the Boeing aircraft is definitely kind of an actionable support, because NASA, if it had procured this kind of technology from the open market, it would have to pay millions and even probably the billions of dollars. But they got the same at a very cheaper price from the governmental agencies of the United States, and therefore they have violated both the concept of actionable and non-actionable subsidies. Likewise, since Airbus also got support from European Space Agency, so it has also upgraded the aircraft seeking that kind of technology. And the WTO stated that the technology obtained by European Union through European Space Agency is definitely part of actionable subsidy and they must be restricted. So in both the cases, it was not that one party was asked to give penalty for the loss being produced, but both the parties were asked to put restraint, and in case they do not, then there will be the larger consequences. So here the matter was not decided, one is uh, the culprit and the other is the victim, but both the parties, they have breached the WTO agreement or the obligations under the WTO agreement, and they were asked to maintain the restraint. And the concept of technological support being provided by the state, or consideration as the state support, was highly debated, and in that respect it was clearly outlined that such like state support which is meant for the which can be used for commercial purposes by those companies should be restricted. That has led to the clear decision in the Airbus Boeing dispute, and mainly the focus is the how the developed nations, they try to use their technological support for their own advantage. That was what I meant to state here. Whereas the developing countries and the less developed countries, they are struggling to get up with their industrial setup or to start the industrial setup, mainly the African countries, where large part of the Africa is still transforming from the rural economic setup to the industrial setup. But on the other hand, the developed nation, although they expect other countries to fulfill the obligations as stated in these institutions, but when it comes to fulfilling their obligations, there they both or they try to set aside these parameters and try to do accordingly as it is in the larger interest of their own companies. Now next is the case of India's quantitative restriction on import of agriculture, textile and industrial products, a very uh, case of very different nature. As we all know, or as I was explaining to you yesterday, that there are various committees working under the General Council. Now, those within that committees, there is one such committee termed as Committees on Balance of Payment. Now, that committee on balance of payment looks after if a particular member state is facing balance of payment crisis, because once the state has become part of the WTO, or it has gained the or it is the member state, then they are supposed to fulfill the obligations as such. And the most prime obligation is that they cannot be protectionist. That means they cannot put restrictions to the imported products from the member state countries. So India is also being a member, it allows the import from all the countries, even if we don't have that friendly relationship with China, but we allow the imports from China also. But there are certain considerations based on which those restrictions can be imposed on the imported goods. And one of the most crucial such criteria for imposing restriction is if a country is facing balance of payment crisis. That means it has less of the foreign exchange available, and therefore it wants to reduce the import. If still it continues to go ahead with those import, then it will not be able to pay the import bill to that very particular country. For example, let's say this is country A. Let's say it's a developing country. It imports products. As per the WTO most favored nation clause or the free trade concept. Now it cannot apply the protectionist measures to these imported products or import of product, but it can apply these protectionist measure in the situation of balance of payment crisis. Okay. Now what is this balance of payment crisis? Balance of payment crisis is when the country is not having much of the foreign exchange that it can pay its import bills. All right. Now what will be the effect of it? Just a moment, I explain this. Effect of balance of payment crisis. Now either the country will have to borrow from financial institutions. Okay, like if country A is having lot of imports and it cannot pay the import bill, so it has to borrow it from the financial institutions. Or the other way is to devalue its currency. So in both the cases, it is affecting its economy. If it is borrowing, then it will be in a debt trap. If it devalues its currency, so it can lead to depression in its market. All right. So usually, for this reason, the states are allowed to follow protectionist measure. That means they disallow import. All right. Now, in this case, India's quantitative restriction on import of agriculture, textile, and products. India was importing not many products from United States, and it imposed these restrictions on the ground that it is facing its balance of payment crisis. Now, firstly, who looks after whether the country is facing balance of payment crisis? It is the Committee on Balance of Payment, and secondly, also by the IMF, the International Monetary Fund, or the World Bank. They also look after whether it's true that the country is facing balance of payment crisis or not. And after their reporting, only the country can take those steps. And India initiated those steps and restricted the imports from United States, stating that it is facing the balance of payment crisis. Now then the committee was established to know whether in true sense India is facing this or not. So the committee found in this case that India has made very good structural reforms. It is not facing that much of financial stress, and therefore disallowing the imports from United States, stating that they are quite expensive, is not the right way to approach the WTO policies. And in that regard, India had to withdraw its protectionist move, and it had to allow the imports from the United States. So the point here is that sometimes the developing nations and the less developed countries, they may be in a situation where they cannot continue with the imports. But in those situations, they can also go, though, although they can go for the protectionist measure, but before that they need to be very clear, or they need to take all the instances to know whether in true sense they are facing the balance of payment crisis or not. Although this clause has been introduced in their favor, that in case they in true sense face the crisis, then they can definitely with, temporarily stop the imports from those developed countries, or any such countries where the import bill is very high. Next come, we have talked about the effect of subsidization on industries which are in competition with the like producers. Now, how we will know that the industry is facing an injury because of the domestic policy or the subsidy policy of a particular country? That is, a determination of injury shall be based on the positive evidence and involve an objective examination of both. Now, why it is important to figure out the injury? Because once the country is known to give subsidies, okay, like, or country B has charged that country A is giving subsidy, and that has led to its effect, or its industry is affected because of the subsidies being given by country A. Then simply by stating this will not trigger the gun, or it will not trigger the legal provisions of the WTO or of the subsidies and countervailing measure agreement. One has to follow the procedure, right procedure. So the first step is to find out whether in true sense the state support has been given. Next step is to find out whether that kind of state support being given falls in the category of prohibited or actionable. If it is prohibited, then that is void ab initio. That means it should not be continued, and the entire policy of the government is void, and that has to be discarded altogether. But if it is a case of actionable subsidy, then further it has to be proved whether because of that actionable subsidy, or the claims being made for the actionable subsidies given by any particular country, whether there is a corresponding injury to the industry of the country that is affected or not. So if country A is giving subsidy to its manufacturer, and country B is exporting the same product to country A, so whether subsidy being given by country A has led to an injury to the industry of country B or not, that has to be proved. That is the second step. And that injury is not simply injury what we mean by the literal sense, whether there is a economic loss to that industry. That economic loss is in the form of there is a reduction in the volume of the sale of that goods, there is a suppression or depression of the prices. So that has to be proved. So a determination of injury shall be based on positive evidence and involve an objective examination of both the volume of subsidized products, that to what extent the subsidy has been given by that particular country, and to what extent it has affected the sale of the product in question, or the product which is affected. The effect of subsidized import on prices in the domestic market of the like product, and also the effect of prices, as I have stated you earlier also, that because of the subsidy there is a reduction in price, or has not been an increase in the price which should have been. So price suppression is something where, let's say, if after 5 years we are expecting there will be a hike in price by about 10%, 20%, which is very normal, but because the same is facing competition from a producer from another country, and for that reason it has not increased the price. But sometimes that can be the the producer from another country has quoted the price not because it is the original price, but because that is the subsidized price. So that is the effect here. It has to be mentioned very clearly. Then the matter is taken to committees. There are committees on subsidies and countervailing measures. They take into consideration what is the real effect of the matter in question. So there is hereby established a committee on subsidies and countervailing measures composed of representatives from each of the member states. The committee shall elect its chairman and shall meet not less than twice a year, and they look after the matter in question. Now, with this, the topic on subsidies for the goods, industrial goods is over, but still the concept of subsidy still has to be discussed, mainly with regard to the agriculture products, and also concerning the subsidies on services, general agreement on trade in services. That is altogether a different notion. But here, when we talk about the subsidies in the terms of the goods, we consider mainly the industrial aspect and the agriculture aspect. Under subsidies and countervailing measure agreement, we have discussed subsidies given for the industrial goods. There is a separate agreement with regard to the agriculture goods, that is covered under agreement on agriculture. The definitional part or the explanation part about the subsidies, that is the same. That means there is no separate explanation about subsidies given in the agreement of agriculture. They take the same explanation as is given in the subsidies and countervailing measure agreement. But the classification of subsidies, as here it was prohibited, actionable and non-actionable, that is distinct in, or the types of subsidies here, as it was prohibited, actionable and non-actionable, is different in case of the agriculture subsidies. So in the next lecture series we will start the discussion on agriculture subsidies. Thank you.